Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And the government in the Eastern District of New York has decided to respond to Bonjean's motion about them seizing Mr. Kelly's trust funds at the BOP. And so, as you guys recall, and I'll drop the video above, the government has tried to seize $27,828.24 of Mr. Kelly's $28,000 that he had in his trust account with the Bureau of Prison, which basically is his commissary money. It's money that people have sent to him to make sure, that he has what he needs while he is locked up. And so they seized those. Well, they haven't seized it, but they requested the BOP put a freeze on those funds to prevent Mr. Kelly from spending them, and the BOP obliged, holding everything with the exception of $500. So hold on tight and we'll get into their response in a second. Okay, so the notice that came from the Eastern District of New York, and you guys, I don't know if I pointed this out before, but the three chicks that tried the case in the Eastern District of New York, they have moved on, and there is a new AUSA who is in charge of trying to get these funds from Mr. Kelly. And so it goes on to say, Dear Judge Donnelly, on August 4th, 2022, the government requested that the court sign a proposed order directing the Bureau of Prisons, the BOP, to turn over the restrained funds held in the inmate trust account of defendant Robert S. Kelly to the clerk of the court for deposit into an interest-bearing account pending a determination as to the amount and applicability of a restitution judgment. On August 9, 2022, defendant filed his opposition to the government's August 4, 2022 request for a turnover order. As the defendant raises a host of novel and unfounded issues in his opposition, the government respectfully submits this letter to the court in further support of its August 4, 2022 request. In short, consistent with the statutory authority and case law, and contrary to the defendant's assertions, the court should authorize the turnover of the $27,828.24 currently restrained by the BOP to an interest-bearing account to satisfy the defendant's restitution judgment, which is yet to be imposed, or to satisfy the court order fine, which has already been opposed. So before we get into that, let's read Jennifer Bonjean's letter that she wrote to Judge Donnelly. It says, please accept this letter in response to the government's motion seeking a NUNC a nunc-pro-tunc order allowing it to confiscate nearly all funds contained in Mr. Kelly's inmate trust account. On August 4, 2022, a reporter from the Washington Post contacted undersigned counsel for comment about an article he was writing concerning the seizure of funds in inmate trust accounts for the purpose of paying court-ordered judgments. During that conversation, it became clear to undersigned counsel that the reporter obtained confidential information from the BOP concerning the balance of funds in Mr. Kelly's trust account. The information was published in a Washington Post article that same day. Within hours of publication, the BOP confiscated all funds excepting $500 from Mr. Kelly's trust account without a court order, without notice, without filing a lien on the property, without filing a notice of default, and without providing a receipt to Mr. Kelly. The government now concedes that it directed the BOP to seize over $27,000 of Mr. Kelly's property, absent the statutory authority to do so, and absent any order from the court. Only after undersigned counsel sent an email to the AUSAs about the unlawful garnishment of funds did the office bother to file a motion with this court seeking leave to restrain funds that it already confiscated. This court should order the immediate return of Mr. Kelly's funds and further sanction the Office of the United States Attorney and Bureau of Prisons for seizing funds without lawful authority. And then there's a note at the bottom that says Mr. Kelly has been repeated victim of BOP criminality while defendant was detained in the Chicago MCC prior to his Eastern District of New York prosecution. The Department of Justice Office and the Inspector General opened an investigation into potential criminal violations committed by one or more BOP officers, including potential crimes of unlawful disclosure of sensitive government information, bribery, fraud, theft, narcotics trafficking, money laundering, ethics violations, and other official misconduct after it was discovered that between July 15, 2019 and January 8, 2020, BOP access logs show that 60 BOP employees accessed defendants' confidential records. One such BOP employee accessed defendants' confidential records 153 times, even though that employee was not assigned to the MCC. A preliminary investigation revealed that the BOP employee sold that information to a well-known YouTube blogger. Judgment was entered against Mr. Kelly on June 30th, 2022. And this is picking back up on her letter. This court deferred a restitution finding until after a hearing currently scheduled for September 28, 2022. To date, the government has providing entirely deficient evidence supporting restitution for any of the identified victims. The court further entered an assessment of $900, a $40,000 JVTA assessment, and a fine of $100,000. This court ordered an immediate payment of $900. The court did not enter a payment plan, nor did Mr. Kelly seek one, since restitution has not been decided and restitution payments take precedent over court fines. In an unprecedented move, the government asked this court for an order nunc pro tunc. Child, we need to look that one up because that seemed like something we used to say in the hood back in the day. Nuck if you buck, all right? Ain't that what that sound like? So allowing it to seize Mr. Kelly's property for application to the defendant's outstanding criminal penalties absent any showing of default. The government cites no authority for the proposition that it may seize Mr. Kelly's property without filing a notice of default or a notice of a lien on the property. Furthermore, no authority exists for the contention that the government may seize Mr. Kelly's property for future application toward judgments that have not been entered. Indeed, the government fails to cite any authority that allows this court to enter the order it proposes. Mr. Kelly does not quarrel with the general proposition that a judgment imposing a fine may be enforced against all property of the person fined, even assuming the government is correct when it argues that Section 3613C provides that a judgment creates a lien in favor of the United States. It does not follow that the government can simply order the BOP to garnish Mr. Kelly's funds without evidence of default and without filing a notice of lien on the property. Indeed, under Title 18, Section 3613C, the government is required to treat the judgment as if it were a liability for a tax assessed under the Internal Revenue Code. The government did nothing more than make a phone call to the BOP directing the warden to confiscate his property. And then there's a note that says, contrary to the suggestion of the government, the BOP Inmate Trust Fund Deposit Fund Manual does not grant the BOP or the government the authority to encumber funds without proper legal authority or an order of court. Indeed, the BOP clearly violated the manual when it encumbered Mr. Kelly's funds without any court order. So then it picks back up and says the government cites several cases for the proposition that a defendant may be ordered to commit substantial funds accumulated in his inmate trust account to unpaid restitution. The authority offered by the government is inapplicable here where there has been no restitution ordered. Critically, the government concedes that pursuant to Section 3613C, the payment of restitution takes precedent over other fines and costs. Because a restitution order has not yet been entered, the government has restrained Mr. Kelly's funds preemptively. Put differently, the funds currently seized cannot be applied towards any court costs since the restitution question has not been resolved. Thus, the government is simply holding Mr. Kelly's funds for future use. No statute or case law allows the government to do so. While victims may have the right to full and timely restitution, they have no right to have the government seize an inmate's funds prior to the entry of a restitution judgment. As to Mr. Kelly's court-ordered fines, the government has not demonstrated that Mr. Kelly is in default or that he was provided with notice of default. And then she cites where I guess that's supposed to take place. The judgment in this case was entered little more than a month ago and specified that only $900 was due immediately. Without any evidence that Mr. Kelly has defaulted on payment of a fine that was only entered 35 days ago, the government was not permitted to seize Mr. Kelly's trust funds. In United States versus Hickman, which was heard in the Western District of New York in 2018, the government moved the district court to authorize payment from the defendant's trust account in order to satisfy the criminal monetary obligation imposed by the judgment against the defendant. The district court held that because the government has failed to present evidence of default in his payment obligations, see also United States versus Woodard, a case from the Western District of Michigan from June 24, 2016, denying the government's motion for an order authorizing the BOP to turn over the defendant's trust account funds to pay a court-ordered fine, absent any evidence that the fine is unpaid or in default. In conclusion, the government acted prematurely and without the legal authority when it ordered the BOP to confiscate Mr. Kelly's trust account funds. It now asks that the court to sanction this abuse of governmental power in the absence of any restitution order and without any evidence of default in connection with his fine. For the foregoing reasons, this court should deny the government's motion, order the immediate return of Mr. Kelly's property, and sanction the government and the BOP for its unlawful garnishment of Mr. Kelly's property. Respectfully, Jennifer Bongine. Okay, so now let me pick back up with the government's response, because they was heated, child. They was heated because they think they right. Okay, so it says, in his opposition, the defendant asserts that the government has unlawfully confiscated the funds deposited into his trust account because the funds were seized without the defendant's notice, without the filing of a notice of lien, without the filing a notice of default, without providing a receipt, and absent statutory authority to do so. These arguments are entirely unavailing and factually inaccurate. So, child, what's this note down here? The defendant filed a notice of appeal on August 11th. However, the enforcement of a judgment of fine or restitution is not automatically stayed by a filing of appeal. The court shall require security for the payment of a fine if a stay is imposed. Oh, so they mad because she filed her appeal. So they think that they're going to hold on to this money just in case. So anyway, they go on to say, first, it must be plainly stated that the government has not seized, garnished, or confiscated any property of the defendant. The government has merely frozen the funds on deposit in the defendant's inmate trust account. Well, sound like you done seized it to me. In accordance with BOP policy, pending the resolution of this motion. See United States versus Sabata, which was a case heard in the district Connecticut, March 4th, 2021. In Sabato, the court rejected Mr. Sabato's objection to the seizure of funds on due process grounds, finding that the government had not seized any funds but rather placed them on hold until the court could adjudicate the pending motion. The court emphasized that the inmate trust account is just that, a trust account, which is controlled by the BOP and can be encumbered at the warden's discretion. As noted in the government's motion, the BOP Trust Fund Deposit Fund Manual specifically authorizes the BOP to encumber funds held in an inmate's trust account before the government seeks court intervention. See Trust Fund Deposit Fund Manual, Federal Bureau of Prisons. This prevents dissipation of the funds while the court considers the government's turnover motion. And this is why I tell y'all, don't send no more money there, okay? Y'all have to figure out another way to help the man, but don't send no more money, because as y'all send that money, they will be trying to seize it as well. So further, as set forth in the government's motion, the government is not required to file a notice of lien in order for the lien to take effect. A judgment of fine or restitution is a lien in favor of the United States on all property and rights to property of the persons fined. The lien arises on the entry of judgment and continues for 20 years or until liability is satisfied, remitted, set aside, or is terminated under subsection B. And then see Title 18, Section 3613. In addition, the Mandatory Victims Restitution Act provides specific statutory authority permitting the turnover of funds accumulated during a period of incarceration for application to outstanding fines and restitution. Title 18, Section 3664N, when a person obligated to provide restitution or pay a fine receives substantial resources from any source during a period of incarceration, that person shall be required to apply the value of such resources to any restitution or fine still owed, emphasis added. While most of the cases that rely on Section 3664 to require, oh Lord, then they got these two long gold notes here at the bottom, but let me finish this paragraph. Require turnover of funds, address unpaid restitution. The language of Section 3664N is clear. A person who accumulates substantial resources while incarcerated shall be required to apply the value of such resources to any restitution or fine still owed. United States versus Kendrick, Western District of New York, June 3rd, 2022, authorizing pursuant to Section 3664N the turnover of money in inmate account to cover unpaid fines, emphasis added. And then they cite a couple of other cases, but the question is, were those people just convicted? Or are these people that have been locked up for a while and have accumulated a lot of money, or accumulated some money, and y'all just trying to get the money? So let's see what goes up here. Okay, Section 3613 does contemplate the filing of a notice of lien, but that provision is concerned with providing notice to a specific subset of third parties. Generally speaking, the MVRA does not require the government to record the lien for it to gain priority over third parties, but it does protect certain limited class of third party interest holders. Then another section, 3613D, upon filing of a notice of lien, the lien shall be valid against any purchaser holder of a security interest, mechanics liener, or judgment lien creditor. In other words, filing a notice of lien does not create the government's lien. The lien is created by entry of the judgment. Upon entry of the criminal judgment, the government's restitution lien arises automatically and attaches to all property of the defendant. To the extent, in the second notice, to the extent that defendant is arguing that there is no specific statutory authority to turn over the funds to an interest-bearing account in anticipation of a future restitution judgment, the government submits that in accordance with the Crimes Victims Act and the MVRA, the government is permitted to use all available and reasonable means to collect restitution judgments. These statutes authorize the government and the court to take steps to protect funds which could be used for restitution, even in the prejudgment context. See United States versus Garrett, which was a case November 20th, 2015, granting a restraining order pursuant to All Rights Act, prohibiting the defendant from receiving the funds of a civil settlement before a restitution judgment had been entered. Once again, are you talking about people that have been locked up for a period of time, or are you talking about people like Mr. Kelly who were just found guilty and sentenced, okay, who was just sentenced 35, 40 days ago, and now all of a sudden you're trying to seize his money, when we know for a fact there are people who are sitting in the BOP today who have been in jail for several years, who are sitting on over $100,000, who have yet to pay restitution to any of their victims, and their attorneys are fighting them having to forfeit their money, but they still have their money to do with as they please. So then it goes on to say the defendant also argues that the court should deny the government's turnover motion because the government did not file a notice of default, but the plain language of Section 3664N does not include any precondition of default. On the contrary, Section 3664 affirmatively mandates that an incarcerated defendant apply substantial resources to any fine that is still owed, that is, to any portion of the total fine that has yet to be satisfied. This is true regardless of a defendant's compliance with or default on a court-ordered payment schedule. In this case, defendant's fine is still owed because he has made no payments, and his debt was due immediately since the court did not establish a payment plan. See Title 18, United States Code 35, Section 3572D1, which states a person sentenced to pay a fine or other monetary penalty, including restitution, shall make such payment immediately unless in the interest of justice the court provides for payment on a certain date or in installments. Like, does he even get the opportunity to ask for an installment plan, or y'all just think because of who he is, y'all can just take every penny that he has? I mean, and then you have like the Larry Nassar or whatever his name is, I can't remember. The guy from the gymnastics scandal. Now, he created some egregious crimes, some egregious acts. Okay, he wasn't dealing with hookers that was looking for a come up, as in this case. This man, I think that the parents were a little slow and the children might have been a little slow also. But the fact that he had over 200 alleged victims and nobody was saying anything. But anyway, nonetheless, why is he not forced to pay any of? I think he has like $160,000 in his account, but ain't nobody forcing him to pay nothing. And the government actually filed to garnish his trust account like 2 years ago, but he hasn't paid a thing. But now all of a sudden, this man who was sentenced, less than 2 months ago, it's an urgency. He got to turn this money over right away. So defendant Principal Lee relies on Hickman versus United States, where the court denied without prejudice a turnover motion because the government failed to present evidence that the defendant was in default. But Hickman is an opposite here. The defendant in Hickman argued that he was not in default because he had made a $25 payment in accordance with the payment plan set forth in the judgment. Further, the defendant in Hickman owed only a fine and had only $3,467.32 in his inmate trust account. In this case, Exhibit A clearly shows that the defendant has not made a single payment toward his criminal fine, which was due immediately. Okay, well, the fine was only $900, so why didn't you seize the $900? Why are you taking the full $27,000? Don't make no sense. So even though he has over $27,000 in his inmate trust account and is subject to a mandatory order of restitution, accordingly, even assuming arguendo that the government is required to show default before invoking Section 3664N, which it is not, this case is clearly distinguishable from Hickman. It is also worth noting that the court in Kendrick explicitly declined to follow the analysis of Hickman after careful examination of the plain text of the statute. If Congress had intended to limit Section 3664N's application to defaulted or delinquent fines, it could have used the terms default or delinquency as it did in other sections of the legislation. Or Congress could have included Section 3664N's mandate within the section of the statutory scheme dealing with the effect of a defendant's default. It did neither, suggesting that Congress intended for Section 3664 to operate as an independent collection mechanism against an incarcerated defendant without reference to the defendant's compliance with or default on his court-ordered payment schedule. Or they may not have included it because they didn't think that there would come a point where the government would be so petty as to try and take somebody's money in the manner in which you have done so. But anyway, in addition, the government notes that the entry of the proposed turnover order will not unduly prejudice the defendant insofar as he remains able to spend the $500 of unencumbered funds in his inmate trust account. Indeed, $500 is not an insignificant amount of money to purchase goods inside a BOP facility where inmates are prohibited from spending more than $360 a month. So now the heifer being sarcastic. I know I think it's a dude, but he probably still a heifer. Anyway, see Trust Fund Deposit Fund Manual, Federal Bureau of Prisons, blah, 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 blah. Findings, and this is from United States versus Schwartz from Western District of New York, February 23rd, 2022. Finding that Section 3664N does not require the court to consider defendants' overall financial circumstances before compelling payment, but nonetheless noting that government left defendant with over $600 in his inmate account. United States versus Kiefer, Southern District of Illinois, May 4th, 2021, permitting government to collect funds in inmate trust account under Section 3664, despite defendant's claim of indigency and reasoning that the government encumbered only $1,856 of his money, leaving $850.80 in his account, which was not an insignificant balance for an inmate to carry in his trust account. Once again, how long had that person been in prison? But anyway, finally, the defendants request that the government or BOP should be sanctioned for seeking to take lawful action here is wholly without any support and should be rejected in its entirety. Courts have inherent power to sanction parties for bad faith conduct. See Chambers versus NASCO, 1991. However, to sanction a party under this authority, a court must make an explicit showing by clear evidence that a party acted in bad faith. See, United States versus Seltzer, 2nd District, 2000. When a district court invokes its inherent power to impose attorney's fees or to punish behavior by an attorney, conduct of the litigation, which actions are taken on behalf of a client, the district court must make an explicit finding of bad faith. Let's see, what else? Here the government's request that the court apply the funds in the defendant's trust account to either the unpaid fines he owes or the restitution he will owe cannot in any sense be characterized as bad faith. The defendant points to no cases where a court has sanctioned the government for similar conduct, and the government's submissions on the matter are ripe with examples of cases where courts have approved identical requests. Given the foregoing, the government respectfully requests that the court grant its turnover motion and authorize the transfer of the $27,828.24 currently restrained by the BOP to an interest-bearing account to satisfy defendant's restitution judgment, which is yet to be imposed. So how is it going to satisfy the restitution judgment if you don't even know what the restitution is going to be yet? But anyway, the government thanks the courts for its consideration of this request and for always siding with us. Daniel G's, okay, y'all know he didn't say that at the end, but anyway. Daniel G's Saavedra, Saavedra. So, yeah, that's where we are with the seizure of the restitution. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.